right, thank you. Welcome everyone for this extremely important webinar presentation that these wonderful people are putting together. This really does impact all of us, what these outside groups are trying to do to the practice of law. And we really do have the who's who on this fight. All these people on this screen right now are really fighting for all of us attorneys and all of the people out there and the clients who need representation and quality representation. That's so important what they're doing. So let me just real quick, because I want to get to the meat of this. It's only an hour program. We're going to be providing all of the materials, so don't worry about that. And again, this is sponsored by the Beverly Hills Bar Association and co-sponsored by LACBA because it's that important. So just real quick, let me just introduce this wonderful panel. Genie, if you want to start the slides. My name is Dan Kramer. I'm a trial lawyer with Kramer Trial Lawyers. I am a plaintiff, PI, and employment lawyer. I'm also on the board of governors of BHBA, and I am chair of the personal injury section. The main moderator is the wonderful Genie Harrison. She's an employment plaintiff trial lawyer and the founder of Genie Harrison Law Firm. She is currently the president of the Consumer Attorneys Association of Los Angeles, also known as CALA, and she is one of the top leaders in this fight. She has presented on this issue numerous times. We also have with us Marta Alcumbrac. She is a principal at the law firm of Robie and Matthai, and for the last 20 years, she has represented exclusively attorneys when they're sued. She's also currently the president-elect of the Association of Southern California Defense Counsel. So you know it's important. We get the president of CALA and the future president of ASCDC together, fighting this fight together. You know that we all need to get behind this. Marta is also a member of the Closing the Justice Gap Working Group with the State Bar and is on the Scope Subcommittee. So she brings a lot of knowledge to this issue. We also have Erin Joyce, who is a former State Bar prosecutor. She's a legal ethics guru. If any of you are on the CALA listserv, she is absolutely amazing. She answers all of our ethics questions, any issues we have, client trust account, anything really. She always gives her time and always helps answering questions. She's the founder of Erin Joyce Law. And like I said, she specializes in representing attorneys when they're going up against the State Bar. She's also the chair of the small firm committee for LACBA, and she brings a lot of knowledge to this issue. We also have Carolyn Shining, who is a trial lawyer at Farzam Law. She represents individuals in mass torts, chemical exposure, class actions, and personal injury. She really has spent so much time on this issue. She actually won the CAOC and CALA President's Award in 2020 for her work with the State Bar, particularly in the Paraprofessional Program Working Group. She was just elected to vice chair of LACBA's delegation to the California Conference of Bar Delegates, and she serves as secretary on the executive committee of LACBA's small firm and solo practitioner section. She also is a biochemist, right? She was a former patent lawyer, so we have some serious brains on this panel here. We also have my good friend Olivier Taillieu, who is a personal injury trial lawyer with the Dominguez firm. He has received numerous 7- and 8-figure verdicts, really great trial lawyer, has been a finalist for Trial Lawyer of the Year 3 times with CALA. And he's also working in Sacramento, working on the same fight. So like I said, we have an all-star panel. I'm very excited. This is such an important issue. So with no further ado, Genie, why don't you take us away from here?
Thanks so much, Dan. We're very pleased to be with you today. We have a lot to get through, and we're going to start off with Carolyn here. Ball's yours.
Okay, thank you, Genie, and thanks for that introduction. And yeah, this has been a real adventure in terms of time and energy and learning where the nature of the bar may be going if people proceed in the way that that hopefully some of you, I've talked to a lot of you, and some of you this may know about this, but this is an update. I'd like to start with sort of the background and the history of where this is coming from. 2019, Erin Joyce and I in the small firm committee, Erin handed me a report and said, you should read this. And it was the technology, access through innovation of legal services through technology. I thought, well, this is going to be interesting. And and access to justice technology. I like it. And I read it in quite a bit of shock. It discussed in ways that would massively change the practice of law as we know it, with some good intentions and some discussion of the needs of Californians and people across the country for additional assistance when they can't afford it, low-income folks. So where did this all come from? Again, a deep background. In London and England in the early 2010s, people started to get involved in how AI would help banking and how banking could be assisted by AI. Academics in England and then Canada, Ontario picked this up and started to write on this, and it became picked up by the ABA, which has several access to justice commissions, talking about how to improve the practice of law. In 2017, 2019, there were two studies called the Closing the Justice Gap Studies, and that was picked up by the California State Bar Association right in the middle of our split between our two into the CLA, the learning educational arm of what used to be the State Bar, and then what they call the State Bar of California, which is now our disciplinary system. So I watched, and Erin and I watched, but I was at every single ATELS meeting after July, monitoring them, and other people came too. We brought, Olivier came and testified, other plaintiffs' attorneys and other attorneys from LACPA, also, from the Trust and Estates subcommittee came and testified, because what was being discussed were sweeping changes using technology just to disrupt the legal system, using AI and trying to find ways, truly innovative ways, to change that. At last, right before COVID, the final report came out in 2020. Oh, and we also, people probably, again, on this webinar, we had 3,000 people comment from LACPA and every state bar in many state bars in California. Erin will probably talk about that. But eventually, in the final report, they split the effort into two groups, and other people are going to talk about this. One is the California Paraprofessional Working Group. That's the one that I've been appointed to through the help of Consumer Attorneys of California, CAOC. And so I've been on that group since April is when we officially started. And I can talk about that later and what that means and what we've done. But ATILS 2, which is basically, it's called Closing the Justice Gap Working Group. Those are the two things. We're first, when I say we, the Paraprofessional Working Group has been working now for almost an entire year. The Sandbox Closing the Justice Gap Working Group is just getting started. So I think you will, so we've got access through technology, access through innovation of legal services. That's the first group that took place all throughout 2019. 3,000 comments were made, but it really was not, the comments were effective in the sense that the group saw that they had to really break these things apart, and their recommendations were completely watered down by the efforts of the people. Again, probably people who are on this call and listening. So we've got the Paraprofessional Working Group, and then the Sandbox, and then I'll let, I think Erin will talk about where those two are going, especially with ethics rules. And just to kind of go back here, where does this really come from today? What is really happening and going on? And we're starting to discuss this, but really this is going to be happening in the next group. It's been clear that what is the goal of these AI initiatives are backed by people. Well, it's hard to imagine. It's hard to talk about. We've given several webinars on this, but the big 8 accounting firms and other technology, high technology, big folks are really seriously thinking about using paraprofessionals at lower cost services to provide non-attorney ownership of these entities, some kind of entities. We're still working on what that'll look like. In Utah, they're starting it. And I think we have some slides on that more. But this is really where this is all going. And it is a stated, this is, as we go forward, it's really actually being admitted throughout these meetings, and you'll hear about it a little bit more. And I'll just let, there's a big question mark. And you'll see at the end, you'll see where we're going.
Sorry, yeah, Carolyn, this is now the balls to Erin to talk about where is this going and how is it coming in? So, Erin?
So basically, after 2018, we became in California a de-unified bar, and Carolyn touched on that. What that really means is that what's left of the state bar, as you know it, is purely discipline and licensing. But you'll note that the mission statement that was adopted is not limited to discipline and licensing. Instead, the mission statement of the state bar talks about protecting the public, supporting the efforts for greater access and inclusion in the justice system or in the legal system. So it's with that hook that you have a state bar now, purely disciplinary for lawyers, looking for new ways to expand their fiefdom. And what better way to do that than to embroider on top of what you already have, the most expensive discipline system in the country, the only state that has its separate state bar court, 5 dedicated hearing department judges, and a separate appellate level to handle nothing but primarily discipline cases and admissions cases involving lawyers. They're looking to create an entirely different parallel disciplinary and admission system for paraprofessionals, and some type of licensing or registration for companies that are not going to be operated or overseen by a lawyer, that are going to provide legal services directly to the public. And the way that they're doing that is using this issue, which is the hot button issue of the day, access to justice. And when most of us think about access to justice, you're thinking about the courtrooms in family law that are filled with pro pers trying to get some kind of orders, and they have no way to pay for a lawyer. You have the lines that used to be there when the courthouses were open at Stanley Mosque and many of the county courthouses at the self-help clinics. That's what we think about when we think about access to justice. But that's not the way the state bar and the people that we're looking at are considering access to justice. They did a justice gap survey, which was heavily relied upon by the ATILS group. And in that survey, the way that they posture the question is that they, at every single level of income, they see that most people don't recognize the legal problem that they're facing. And that's how they are basically co-opting the issue of access to justice to completely change the advertising rules and to allow investment of non-attorney money into law firms, ownership of law firms by marketing companies. So that way, all those people that right now recognize them, what their problem as is bad luck or a bad boss, as a legal problem. And in these meetings, both the ATILS meetings and I know from the paraprofessional working group meetings, they have pretty much have stated that they're not trying to replace or supplant the people that need legal aid, the people that don't have money for legal fees. They're talking about the middle class legal market. And that's what you see here in the strategic plan from the Board of Trustees, to explore options to increase access to licensing of these paraprofessionals, limited the triple LTs like they had in Washington State, a system that has been disbanded, by the way, after 5 years of attempts and at incredible expense. And basically, from what I saw at the last paraprofessional meeting, they're talking about these paraprofessionals that have some limited education, but certainly not a law degree, will be, if they pass the exam, they'll become specialists in their area, able to provide legal services to the public all the way up to jury trial, but excluding jury trials. That is what's on the table. And in fact, that is the default position that was adopted by the Paraprofessional Working Group.
So, Erin, there's a question about how Business Profession Code 6125 that basically you have to have a license to practice law. Will this just be an exception to that?
The way that they're talking about this initially is as a sandbox or pilot, what most of us would consider a pilot project.
So someone also asked what sandbox means exactly. Can we just quickly explain that?
Sure. What that really means is it's another term for basically a pilot project, but here's the problem. Normally, you would think of a pilot project would have a sunset provision. Like, we're going to try this for, I don't know, a year, 2 years in a limited area. When they're talking about these, licensing of paraprofessionals, they have identified certain counties where it will be rolled out, but there's no sunset provision. So basically, if this cat is out of the bag, it's simply going to spread throughout the state.
And
Great.
another,
Okay.
there's
Yeah.
another question.
So,
Go back. What is AI? Artificial intelligence, and that is a way they call about one-to-many. So you can use computers as in Rocket Zoom or LegalZoom, but on taking your data. For example, if you file a divorce proceeding, then you would click on something and you would release and waive conflicts, and they would save that in a database and then make it more intelligent. So the next 5 people who have a similar kind of thing. That's the concept. Is you take computers, and computers, they work, that's a little term, sandbox, they go into the sandbox and they make castles and sort of things like that. It's a computer software term. So those are the 2 things, artificial intelligence and the sandbox terms. So, okay, so let me, again, I only limited amount of time here. This is something that people, again, how can someone who is less than someone who's had years of experience and training to issue spot really handle some of these very complex issues? Well, that's been thought about a lot by the work and an amazing amount of work at the State Bar. This is a 1-page sheet that came out with the original Access Your Technology final report. And it sort of goes into what we're facing in terms of messaging and in terms of the purpose that is felt with regard to what's stopping access to justice. So this can be found on the State Bar website, but let's walk through some of the big areas that this lists. And this is from our State Bar, absolutely. There's several different areas that have been focused on. Only lawyers can provide legal access. These are the problems with the future. Only lawyers, not entities or businesses, are regulated by the State Bar. And only lawyers can own law firms. That's a problem. And lawyers cannot share fees with non-lawyers. So a couple of these.
Carolyn,
Okay.
fast, Carolyn. You're saying that's a problem. These are
Right.
actually identified. Tell us what this means, what the State Bar is doing here. These are identified as problems, right?
Right. This is what the lawyers who were deemed to be elitist and difficult to find, and we turn away clients who are not the biggest cases. And then it ties into, the Walmart law. Who wants to own a law firm? Cooper's, Price Waterhouse. KPMG would love to own a law firm so that they can provide one-to-many kinds of service. You can find this. We don't have to go through this, Genie, all these different slides, but yeah, these are the problems. When people wrote in with the 3,000 comments that we had, they said basically, we're going to not listen to anybody who says only lawyers are regulated by the State Bar because technology companies can come in and do it better. Well, we don't know how, but they will. Lawyers can own law firms. Well, that's elitist. Why would we let only high-level, really super intelligent people do this and bill $500 an hour? That's not fair. We need incentives to investors to get VCs involved. And then what's the 4th one we were going to talk about? The non-lawyer ownership. And I think Erin will talk about that a little bit at the end, but that's changes to, there'll be paraprofessional ethics rules that are still being discussed and decided. Many people wrote in 2019 and said, how can you do this? The first committee couldn't figure it out. And now we're in the heat of how do you let lawyers own law firms? Well, the answer, non-lawyers, the answer is you just let them. And so, the changes to 5.4 allowed nonprofits to help earn more in connection with cases that were brought in. That was a change that everybody supported. But here in the next few months, the concept that non-lawyers can own law firms is on the table. It's smack dab in front of us. Basically, the thoughts process is fine. As long as a paraprofessional owns less than 10%, 49%, you name it, they can, the amount of the changes from the legislation and the regulation committee is a dream wish list of what people would say to create this entire new category professional and have them be owned by large corporations under the guise of helping access to justice. So with that,
I would just like to say one thing about this. The rules of professional conduct are not there to protect lawyers. They're there to protect clients. So the primary interest of the State Bar should be protection of the public. And almost all of what they're talking about now is going to adversely impact the provision of quality legal services to those same people that they're supposed to be protecting.
Right. Okay, so I'm going to jump in here and just talk a little bit about the current justice gap study, the survey and the study, which you'll hear referenced numerous times in all of the discussions amongst the paraprofessional working group and the access to the closing the justice gap working group, et cetera. So the State Bar commissioned another California Justice Gap survey resulting in a study. And they paid this entity or a program from University of Chicago called NORCS to conduct this study. And what they did was they surveyed 3,885 Californians about the civil legal problems they faced and what they did to resolve them. They also surveyed regarding these other areas that you see here. And these are some slides from the State Bar itself. I'll identify when it's not one of the State Bar slides. So from that survey of 3,885 people, this is a slide from the State Bar which reflects its findings. It says that 55% of Californians surveyed experienced at least one civil legal issue. 13% of Californians experienced 6 or more problems. This is key. Health, finance, and employment were the main legal problem types faced by Californians regardless of income. However, they concluded that fewer than 1 in 3 Californians sought help. And then you'll see some of the additional conclusions. And they point to this fewer than 1 in 3 sought help as indicating a knowledge gap about legal issues and a gap in ability to access legal help. And you will also hear them referencing the fact that they believe that this survey indicates that the quote unquote justice gap exists at all income levels, both above and below the federal poverty level. And that's a very important point that they repeatedly point out, is that, again, you've heard, I think Erin mentioned it, that they really do intend to go into essentially the middle class in terms of remedying the alleged justice gap. And I really want you to understand that they refer to this as an emergency, that the system is broken in California. However, when you look into the details further, which I have done, I actually went through the survey itself to look at the questions, and I'm calling out the employment questions, which are, of course, this is the area in which I practice. There were, just, 9, 12, kind of a dozen questions-ish. And these are the only questions that were asked. In the entire survey, these are the only questions that are asked, okay? And as a result of that, these are the conclusions they came to. This is my slide, as was the prior one, calling out all of the employment questions. It is my characterization that I do believe that the employment findings are misleading. From those prior questions, just those questions, that's it, okay? They have concluded that the crisis in access to employment resources, legal resources, would include non-payment of wages, denial of workers' compensation, unsafe working conditions, unfair termination, denial of accommodation, denial of unemployment benefits, inadequate handling of grievances, and sexual harassment. When you get down to it and you count the actual numbers, there were 123 people who responded. Hold on, I'm sorry, this is trying to kick me off. Who responded that they had employment problems. 66 of those 123, or only 54%, sought legal help. Half of that 54% obtained legal help. Only 12 people, or 21% of those who sought legal help got none because of cost. However, respondents were not even asked if lawyers rejected their cases for a lack of merit. This is why I say, I believe that the survey itself and the results are misleading, and it's important for people to understand what's really in that survey when we're talking about radically changing the provision of legal services and the regulation of legal services in California. Okay, all right, Carolyn.
Jeannie, Jeannie, we're getting a couple questions about how is this working around the world? I know in Europe, I think non-lawyers can own law firms, I believe. How is it working there? Have there been studies about that? Or is that what they're using to say it should work here?
Yes, and they are using other country systems to try to justify using the same system here, but they have never actually had a prohibition against non-lawyers owning law firms in England, for example, as far as I'm aware. I'm not an expert, but we just have a very different system, and that is my quick answer. So I want to get to Carolyn on this because she's got a lot to go through on breaking down what's really been happening in the paraprofessionals working group.
Okay, and I see we've actually got a visitor. Ira is on the, Ira Spear, who's another member of the working group. So Ira, throw those questions at me. I don't think it's a secret what our positions are back and forth. Okay, so let's go to a little bit more history. On the paraprofessional side. So this is something that, again, has been not just in California, but is something that is all a great deal of the country in the United States has been working on for several years in the last 5-6 years. And you look at this slide. Washington State had a family law program that, again, Erin said was sunsetted last year because of expense. New York has had some courtroom, what they call navigators, some of whom are volunteers to come in and help people fill out forms and do a little bit of help with forms, that kind of thing. In Utah and Arizona have been sort of the hotbeds of this. Where we talk and we're in our meeting about what they're doing, and they have these several limited areas and different kinds of practice. And I don't want to go into it, take forever to go into all of this. And again, Oregon, Minnesota, North Carolina, and maybe Colorado are all thinking about it. And Ira points out a good thing. All of the Justice Gap Sandbox and paraprofessional meetings, and we'll show you, I think, at the end, how to get on these meetings and watch the Zooms and give public comment. So Jeannie, I'll try and go through this really fast. And a lot of these slides are from the actual working groups and the things that we're doing. These are actual State Bar slides. So last April and June, we had our initial meetings on the paraprofessional group. And what we were started to discuss was brainstorming sessions where we discussed the kinds of areas we would like to see considered, the kinds of areas that really didn't fit with what we wanted to do, and then things that might fit and not fit. And so about 12 different committees or 10 different committees were formed of separate subgroups, and we met at least a dozen times. I'm on 3 or 4 of those groups, and really hashed out and went through with some experts in each field that were invited to talk about all these different issues that were, as much in detail as we could. And then, we have narrowed it down. In the initial program has been narrowed considerably, partly in response to public comment, partly in response to how technical some of these issues are, partly in response to the fact that there are entities and places and government agencies that do help. A lot of people from public counsel and BetSEDEC have been commenting in as well. So next, this is the schedule that we've been on, and you can see that that it's been really active. We went through a lot of subject matter areas like I said, from April through October. Then the regulatory, licensing, and disciplinary and pilot program committees, a lot of subcommittees, a lot of reports. It's a lot to keep up on. But those are coming through now to talk about how these new entity will be licensed. Boy, I can barely see that. This is, I don't know if you can see it, but I've got a bigger one here. Yeah, you can see here the areas that were excluded. A lot of areas excluded because they would wrap into federal practice, and this cannot only be state authorized. Some of the things, consumer debt is one of those things that we're hotly discussing, and I could go into that again. And I reckon probably
Olivier will. Yeah.
Olivia will. Yeah. So there's some consumer debt and general civil issues that, again, they're very limited. But this is again, this is a pilot program, and the Sandbox Closing the Gap Justice Gap group will be using this as a roadmap. So that is of concern. Go ahead, Genie. Try and get through all this material.
Right. I think we're to Olivier next. So,
Right.
Olivier.
So
Right.
this is the call to action, and this is where I tell you that your participation in this process is key, and it works, right? So a lot of these, not a lot, all of these committee and subcommittee meetings are done publicly, and we'll have in the resources at the end of the presentation, we will give you the URL, the web address, where you can register to receive notification of all the different meetings. And what I would like to share from all the panelists today is that your voice matters. And your voice has an impact on the decisions that are being made at the subcommittee and the committee level. And so I cannot be more clear that the more of us attend these things, the more of us share our experiences, our concerns, share the points that we want to make against these types of programs, the more of an impact we're going to have. And I say this isn't, pie in the sky, is because I've seen it. We've had these subcommittee meetings that I've attended, that I've provided public comment to, and we've been able as a group to really limit and minimize the impact of certainly the paraprofessional discussions and decisions that have been made. So the next slides are going to show sort of, what was in initially, and then ultimately what was taken out. So if you look, for example, at the consumer debt and general civil, which initially was a very, very broad category, through the participation of CALA members, CELA members, LACBA members that have come in and testified, we've been able to limit it dramatically. So they've taken out bankruptcy, they've taken out identity theft, they've taken out unfair, deceptive, and lending practices, problems with credit repair services, payday and short-term lenders, fines and fees from criminal or juvenile cases, car repos, and so forth and so on. So that at the end, the subcommittee recommendations are very narrow in focus. If we could go to the next slide. Same thing. Did we miss employment? Sorry, I must not have seen
it. Was the first one.
That's okay. So employment, and I got to give, a lot of credit to Genie, and obviously Carolyn, who's on the subcommittee, but I have to give a lot of credit to Genie, because Genie really rallied the troops in the employment area and was able to bring a lot of experts, people who give public comment on some of the issues that were being discussed, and really limited the impact that the subcommittee ultimately is having on the areas of employment. Now, obviously, this is just starting. I mean, this is a new process. This is a new mission for the state bar. So we need more. And I think, if you get anything from this webinar, if you get anything from this presentation, I urge you to get involved. Get on the notification, get the meeting notifications, attend the meetings. You don't have to attend all meetings, but attend the ones that you can, and let your voice be heard, right? Public comments come first, which of course is not the most convenient because you don't get to hear what they're saying before you comment. But public comments come first. They're limited to 2 minutes. Make sure you keep your comments to under 2 minutes or you will be cut off, but be heard, because it matters. And we've been able to make a difference up until now. And I believe that if we all rally together, and the more of us there are, the more not intimidated, I think is the wrong word, but I think the more they realize that there really is a movement against what's going on here. We've had 2,000, 3,000 people attend. I mean, it makes a difference. So that's the pitch. I mean, that is my pitch for this program. Our livelihood really does depend on this, and it cuts across the board, whether you're on the plaintiff side, defense side, whether you do commercial litigation, whether you do personal injury litigation, whether you do employment litigation, whether you're representing lawyers in front of the state bar, whatever your practice area might be, it will be impacted by this in some fashion. So it's really important that we all get involved.
That's awesome. Thank you, Olivier. And Carolyn's going to tell us about what the decisions are regarding the licensing and what does this paraprofessional thing look like in reality for the regulations. Go ahead.
Okay, so right now, and April 19th is going to be a massive meeting. There's so much content that's going to be happening and given and reports on April 19th. It's one of our key meetings in discussing the training, the discipline, and the regulation through the changes of the professional rules of conduct, which will impact lawyers, changes to statutes. Here's some of the things that, and it's constantly changing. I mean, these things are constantly being revised. It's hard for even someone on the committee to keep up, but talking about contingency fees, so paraprofessional can actually make a living, because sometimes making $200 for an appearance wouldn't be good enough, wouldn't be sufficient. Referral fees, what do you do when a paraprofessional is going finally beyond the scope of their license and has to refer something as stated to a jury trial? 1,000 areas of training, that's less. These are some of the things. Again, you will be a new licensee from the state bar. The next, and this is what, and I voiced my, the next slide here, this is what I have voiced my concern about. If you could switch to the next one. Oh wait, I'm looking at the wrong thing. This is on March 26th, this was a vote on, after we've done all this work, and it's no secret, about my position on this, after we've done months and months and months of work about the areas and talking about how the paraprofessional could be in court and not be in court and where would they be effective, we took a vote that was a blanket vote that was just a complete shock. Paraprofessionals, this is the default working group position regarding in-court representation. They might provide full in-court representation, no limited scope. This is, you were in court, you were dealing with motions, you were doing everything except jury trials. And now all the subcommittees have to go back and revisit these issues. But this is where we have ended up, full in-court representation. I think there was a slide too far back, but in family law, and I'm not a family law lawyer, again, on April 19th, there will be a memo that comes out discussing the whole range of in-court representation, as opposed to like in New York, being able to stand there and help people more fill out forms a little bit better, or behind the scenes, helping people again, as a legal document preparer. So these different levels that we discussed, this is it, full in-court, the whole kit and caboodle. There will be a pilot here. It will be started only in these smaller counties, except for Orange County, so that we can get some kind of statistics and data on whether it's working. And then these are some of the big areas: family law, housing, unlawful detainers. The collateral criminal is expungement, so that's something really a lot of people can deal with anyway. I'm not on that committee, but and so again. And Erin actually can talk about this. So I'll let Erin talk about this slide a little bit more, because this has to do with the changes. Again, this report is going to come out on April 19th. You'll be able to see exactly what is being proposed with regard to the paraprofessional rules of ethics. And again, unlicensed practice of paraprofessional licensing is how it's proposed to have a paraprofessional. There's going to be a whole layer of what they're able to do versus the unlawful practice of law. They're just saying they're two different things. That's your license, and here's how we're going to define it.
I would just like to add here that it took 25 years and 2 separate rules revisions committees to get the current rules of professional conduct adopted, which became effective in November 2018. And those rules of professional conduct are there to protect clients. The primary mission of the state bar should be to protect clients. This discussion is not about protecting the income of lawyers. And don't let those folks pigeonhole us that way. That is how they're trying to respond to the reasonable objections to what they're doing. I mean, go get a scalpel and start doing toe surgery at this point. I mean, really, there's a reason for licensing. There's a reason for minimum competence, and that is to protect the public. So I would just say, it took two rules revisions committees, and many of the changes that are being proposed under the guise of access to justice, including what will be amazingly widened advertising rules. If you have concerns right now about the advertising for lawyers, you don't even know what they're expecting. The kind of limits that, basically pulling apart all of the limits. And that is, again, in the name of access to justice. And that is not going to protect the public at all. That is going to hurt the public because the public is going to see, their phones are going to be bombarded by text messages, which will soon no longer be solicitations if these new rules are adopted, by the way. And the public who aren't lawyers, who don't have legal background, are not going to be able to differentiate the lawyer from the quote paraprofessional quote specialist. And by the time the damage is done, they're going to have no recourse. And imagine the kind of litigation that will be coming forward when the paraprofessional who only can do work up through a jury trial has had the clients waive their right to jury trial. That's just one of the obvious problems that's coming because most of what is being considered is ill-conceived. They literally, at the last meeting for the regulation subcommittee, were redrafting, redline the rules of professional conduct, making changes without knowing and without even really caring how it's going to impact other rules and how it's going to undermine the justice system as a whole. This is not about protection of lawyers. This is about protection of the community.
Thank you, Erin. And so we're about to hand this over to Marta, but I just want to make the point that this is what you'll see if you just get onto the paraprofessional working group agenda or State Bar Justice Gap agenda. If you Google that, you're going to see that all of the meetings that are scheduled, as you can see, many happen each week, and this is updated pretty much daily. You will then be able to also see, if you click on one of these red links for the meetings, you basically get taken to the page for the specific meeting where you'll be able to zoom in and watch. And this is the link underneath here. But you can just Google Paraprofessional Working Group agenda and meetings, and you will certainly find that. We'll provide that later as well, and you can subscribe. So you can get email notices. So Marta, you're here to talk about the Closing the Justice Gap Committee.
Hi, everyone. Okay, so as Carolyn mentioned, there are two groups that are working simultaneously studying this justice gap issue, or as it's called, a justice gap issue. There's the paraprofessional group, and then there's the Closing the Justice Gap Working Group. And I'm a member of the Closing the Justice Gap group. And someone asked earlier about what is the sandbox, and I want to touch upon that, and I want to actually use the definition that came out of the ADLs, the first working group, or the first group that was studying this issue, and they've defined this as it's to function within the state of California as a framework established by a regulator that allows participants to test innovative business models or offer products and services in a controlled environment under a regulator's supervision. Note that there's nothing in there that speaks about the law. And the sandbox model is to allow for the gathering of data to assess impact and protect against consumer harm. And the structure of the sandbox is really is structured to encourage innovation to enhance the delivery of and access to legal services through the use of online legal delivery models and allow entities that are not currently allowed to under existing rules of professional conduct or under the statutes that govern the unauthorized practice of law in the state of California. Now, the working group that I'm a part of is currently divided, and we just began our work, I should add, in January. So we've really just gotten, kind of up and running. But currently, there's just two subcommittees that have been established. There's the Scope and the SAGE subcommittee. And the Scope subcommittee deals with the purpose of the sandbox, the intended benefits to be achieved, and primary public protection objectives. The SAGE subcommittee is going to be looking at the structure and governance of the sandbox and its participants, including changes to any statutory changes that are going to be necessary to implement the sandbox, and changes to the rules of professional conduct, which, as Erin mentioned, have taken decades, if not longer, to finally craft and get approved in the state of California. I want to also talk about what's really the current debate that's going on in our meetings. And again, like Olivier said, I really do encourage people to attend these meetings, pay attention, and find those links and enter public comment, etc. But right now, what we're really grappling with is how tall the walls will be for people to, or entities to, enter the sandbox. Are they going to be, for example, are the activities to be governed by the sandbox or by the regulator of the sandbox going to only be directed to the currently underserved or unserved consumers in California, which would seem to track with the Justice Gap study? Or will the walls be so low that admittance will be allowed to essentially anyone that is claiming to offer any kind of innovative legal services, and who, even though those legal needs are currently being met by practitioners in the state of California? And the concern being expressed here is that if the walls to enter the sandbox are restricted to just the underserved, innovators are not going to want to enter the sandbox because there's not going to be sufficient profit to motivate them to come in. But if the barriers are lowered, then more innovative actors will enter the market, make it more competitive, which will reveal more innovative legal services. But I query whether or not we want to be jumping into this arena and talking about economic models when we're talking about the practice of law and, offering quality legal services to California residents. And, the deregulation of the legal market is being discussed as the best for innovation. But again, on balance, will quality legal services be rendered by competent actors, people in the sandbox that maybe have different mores, values, and certainly not trained to render these legal services? And the other thing that we're also talking about is what standard will these legal services be measured by? Will it be lawyer-like quality, or something below that, or something completely different? And as we touched upon earlier, the Supreme Courts of Utah and Arizona have approved sandboxes in each of the states. Under Utah's program, as well as Arizona's, it can be viewed as an open marketplace. In other words, the sandbox regulators are not necessarily taking into consideration the target audience of the citizens of Arizona or Utah. They're just trying to innovate the legal market. In Utah, for example, Rule 5.4 allows for fee sharing with non-lawyers. It allows non-lawyer ownership of law firms and other entities providing legal practice services. Rule 1.5 is going to be removed, and referral fee rules have been changed as well. And the Arizona Supreme Court has eliminated the ban on non-lawyer ownership of law firms in that state. And in talking briefly, I want to talk about the members of the working group that I'm a part of, because I think it's very interesting who has been chosen to sit on this committee. Of the 17 members of the committee, 5 served on the ADLS committee, and 4 are not even residents of the state of California. One of the co-chairs, Rebecca Sandifor of Arizona State University, has dedicated much of her professional career to regulatory reform and access to justice issues. She's very knowledgeable in this area. But she's also served in Utah in establishing its sandbox, and is still working with the Office of Innovation of Legal Services in that state. There's also, there's technology experts, there's an economist, there's an entrepreneur that sits on the committee, there's a trial judge from LASC, there's a Stanford law professor who's study of his practice area focuses on the intersection of law and artificial intelligence. There's somebody from a public interest law area. There's also a CALA member. Michael Liberty Starr is also part of this group. Also, there's a member of the working group who's co-chair of Utah's Sandbox, who's also serves on the committee. And I believe there was a question that was answered earlier about other countries that are doing this. And coincidentally, there's a member of our committee that's from the United Kingdom who consults internationally on the practice of law and the delivery of legal services. And the UK has a very different legal structure and legal marketplace from California. Their rules of professional conduct are extraordinarily brief. They mention confidentiality, honesty, and dealings. There is no correlation to what we have in California. It's a comparison of, apples to oranges. It's essentially a single sheet of paper, and it really has never contemplated non-lawyer ownership of law firms or fee sharing prohibitions. That member of our committee has been very vocal about what he believes California should move towards, which is a very open marketplace in allowing a lot of unregulated or deregulated practice of law. Completely different than what we are accustomed to in this state. And again, in closing, I just want to say your practice is going to be affected by the recommendations that come out of both the paraprofessional and the Closing the Justice Gap working group. I encourage everybody to stay informed, pay attention, talk to your colleagues, talk to the members of your law firm, talk to your bar, the various bars that you may be members of, and make sure you are paying attention. Thanks.
Thank you so much, Marta. Okay, and Erin, you want to just guide us through a few talking points real quickly on the Board of Trustees?
Well, probably you noticed in the last few years you haven't voted for any of the Board of Trustees. It used to be it would bounce back and forth, the presidency of the state bar between San Francisco, LA, and sometimes San Diego. You have no impact at all who sits on the Board of Trustees now. We now have a 13-member Board of Trustees of the state bar, all of whom are appointed. There are 6 public members and there are 7 attorneys. And every one of them is appointed either by the Chief Justice, by the head of the Judiciary Committee in the Assembly or the Senate, and also the governor. Sean Selig actually is the one and only member of the Board of Trustees that has any background on state bar discipline, because he has represented respondents in discipline proceedings. So he actually probably has more understanding than everybody else on the Board of Trustees about how the state bar discipline system works. However, it's very important to realize that every one of these people that's on the Board of Trustees is there with a constituency that is not lawyers and also has other interests other than protecting the public. Many of the people on the Board of Trustees are there because they have connections to Silicon Valley and hedge funds. And those are the people that are really behind this leveraging one-to-many concept of basically we don't need lawyers to provide legal services. We need computers to provide legal services. And the fact is lawyers would innovate. Of course we would innovate, because whatever makes for provision of competent, less expensive legal services to the public, we're certainly all behind. That's not what this is about. This is really about, in the name of deregulation, in the name of providing access to justice, allowing non-attorney ownership of law firms, which will consolidate the legal market. You're going to have some even right now in the United States, only a very small number of law firms control more than half of the dollars spent on legal services in the country. And they're looking to do the same thing that they did with business law for people law. Right now in California and every state, the majority of lawyers provide legal services in either solo or small firms. That's not going to be true if this continues, and it's not going to benefit legal services provided to the average client. Because if it turns out, and this is very important, and this has happened, where if you have law firms controlled by the insurance company or by big conglomerate, they're not going to be putting loyalty to the client first. They're going to be putting, short-term profits of their shareholders first. And so a lot of clients, without even knowing about it, are already going to be having their cases shortchanged with no recourse. So if the state bar was really interested in public protection, most of what we're talking about wouldn't be happening.
And just before Olivier, I think, closes this out, Erin, I just would like to just add, there's a comment in the chats that how do we make some of this work? And there have been a number of proposals in the paraprofessional group that could work. It's this broad scope that I think has really come about after months and months of work. That's what I'm kind of concerned about, is how it's changed dramatically all of a sudden. So that's what, there are lots of little ways that we can improve access to justice. I think that's why I got on the paraprofessional committee, but it's really the scope of it has just exploded wide open in March here. So yeah, Olivia, I'm sorry to butt in.
So this is where before Olivier comes in. This is where you go, and this is what it looks like when you subscribe to get notices about these meetings, which you need to do. So please do this. And Olivier, you get the danger slide.
That's right.
And those that follow.
Look, I've worked for a large law firm on the defense side. I've run a startup. I now work on the personal injury side with a significant presence in advertising. And so I think that, I have a pretty good understanding of all of the issues that are being involved here. One of the motto of tech and startup is move fast and break things, right? It's literally what underlies the concept of new business models in the technology arena. And it's simply a model that does not work in the legal field, because when we break things in the legal field, clients get hurt, right? Clients get undersold. We see this every day in my current practice where clients are not being well represented, and that's by lawyers, and their cases are being undersold. All that's going to happen is you're going to see more and more and more of that, because corporations, in tech in particular, don't care so much about the product. They care about the profits. And the way that they achieve maximum profit is by first running everybody out of the business. Look what happened to taxi cabs. Look what happened to delivery services. Look what happened when these corporations come in with unlimited resources that are able to literally get everybody out of the space. And then the prices go up and the quality of the services go down. And this is what's happening. And this is precisely what this commission is intending on doing, is to elbow everybody out so that they can then come in, provide lesser service at the peril of the clients. I don't know if we have any more slides after this, but again, tech has done a lot of good things, and I think we can harness the positive aspects of technology in the legal practice. And I think by and large, all of us have, to the extent that's allowed by the rules. But again, tech has a habit of favoring profits over service. And if we let this happen, if we let these systems come in, it's going to be Amazon law, it's going to be Costco law. And we're not talking 20, 30 years from now. We're talking tomorrow. So again, I'll reiterate my call to action, because your voice matters. Get involved, be informed, sign up for the agendas, attend the meetings, let your voice be heard. And hopefully we can put a stop to this before it gets started. Obviously, there are different layers of this. It'll have to go through either Supreme Court or legislation signed by the governor. But we don't even want to have that fight. We want to nip it in the bud and get this thing done before it gets anywhere. Thank you for your time.
Thank you.
All right. Thank you, guys. Thank you for everyone attending. I wish we had more time. There was a lot of good questions in the question and answer. I wish we had more time to go through it. Unfortunately, we're limited on time. But as you can all see, this is an extremely important issue that we need everyone to get behind and support, sign up. Because I know all these people, like I said, who are on this panel are doing an amazing job volunteering their time to really protect all of us and our clients. So we appreciate it. Please share with your friends and your colleagues. Let them know about this issue. Let them know about this fight. Because not only do we need to get the attorneys behind it, we need to get the public behind it to really make a difference. So thank you. Anything else anyone wants to add before we sign off here? Okay. All right, guys. Thank you so much. Appreciate it. Thank you for your time.